Good afternoon. My name is Carrie Filiberto, and I'm the Senior Director and Counsel of Contracts and Construction Law at the Associated General Contractors of America. I also have the privilege of being the Deputy Executive Director and Counsel for ConsensusDocs, a coalition of more than 40 industry associations. I want to thank you for participating in today's 60-minute webinar. A copy of the PowerPoint presentation will be emailed to you after the webinar. You will also have an opportunity to ask questions of our speakers. Please type your questions in the questions box, and we'll have the speakers address them at the end of the presentation. I would now like to introduce our esteemed speakers, Tim Gibbons and Sam Reaves. Tim is the chair of the construction group at Chambliss, Bahner, and Stophel PC in Chattanooga, Tennessee. He focuses his practice on construction disputes and contract negotiation and drafting. He has lectured extensively on a variety of construction law topics, is a founding member of the Tennessee Association of Construction Counsel, and is listed in the Best Lawyers of America for construction law. Prior to attending law school, Tim practiced for 7 years as a licensed architect. Sam focuses his practice on commercial litigation and construction law at Troutman Sanders in Charlotte, North Carolina. He also handles real estate and commercial litigation. Sam has represented clients in state and federal courts, the North Carolina Property Tax Commission, the North Carolina Real Estate Commission, and in arbitrations before the American Arbitration Association and the International Chamber of Commerce. He is listed in the Best Lawyers in America for commercial litigation, and construction law. We're very lucky to have such prominent industry attorneys for our presentation today. I would like to take just a moment for those of you that might not be familiar with ConsensusDocs and AIA to just in a minute or two give a very brief description. ConsensusDocs are standard contracts that are written for the design and construction industry. ConsensusDocs is a coalition of 40-plus design and construction industry associations that come together to write these best practice documents. The docs in ConsensusDocs actually stands for designers, owners, contractors, subcontractors, and sureties. So this large coalition of members got together to write best practice standard documents. AIA, the American Institute of Architects, has their own industry standard contracts. Unlike ConsensusDocs, it has the 40-plus coalition members. The AIA documents are endorsed by the American Institute of Architects. And now I'd like to turn it over to our presenters to tell you about some of the differences between the ConsensusDocs and AIA design professional documents.
Thanks, Carrie. This is Tim Gibbons. From the beginning, I'm going to make the disclaimer on behalf of Sam and me that we have a very short period of time to go through some very important differences between these sets of contracts. So obviously you cannot cover everything. We'll do our best, but again, please feel free to ask questions. Both of my topics are more technology driven, and I've done this presentation before. I think it's still worth going through at least a minute of the history of the technology of producing design documents. Carrie mentioned that in another life I practiced architecture for 7 years, and that 7-year window sort of let me see almost the whole history of how design documents are produced. I started out with a drafting board and a T-square and triangles and pencils and pens. In the 1980s, CAD was being developed, and as CAD became more powerful, became more sophisticated, you had the ability. I think we need the next slide up, by the way, Carrie. They had the ability to put information in the lines, and the next one as well. And then after you had the ability to put information lines of the drawings, you had interactive databases, and then you eventually got up to cloud computing. So go ahead and go to the next one. And this is the theme for anything technology driven, you know, the same advances that revolutionized how you produce design documents are revolutionizing the way we deal with each other in design documents. So look at the competing interests. These competing interests have been with us forever. I put the owners first. Owners often have a need to protect their own proprietary information, which sometimes, for a specialized project, that could be the arrangement or configuration of the project itself, the elements of the project. I mean, many owners regard the way they put their buildings together almost as a trade secret. On the other hand, the designers certainly have their desire as authors to protect their works. And so you have these sort of different interests, and the question is, you have all these intellectual property rights, you have all these protectable interests in information. Who should own it? Who should control it? Who should be able to decide what happens with it? Go to the next slide, please. The ownership of documents is handled differently under ConsensusDocs under the 240 and the AIA B101. Under the AIA, I would say that's sort of the traditional approach. The architect and its consultants are the owners, and they have all the intellectual property rights, including any intellectual property right you can imagine. ConsensusDocs, the 240, on the other hand, begins with the idea that the owner gets ownership of what I'll call the construction documents, the data prepared by the architects or consultants, provided they pay. Even under the ConsensusDocs, the owner does not get the copyright. Now, if you go to the next slide, though, even under ConsensusDocs, the owner has the option of being granted the copyright. And that's contingent on the owner making the payments required under the contract, including a stated copyright fee. And this brings up one point about ConsensusDocs that I think Sam will probably hit on as well, and that's that the ConsensusDocs documents in general use a sort of fill-in-the-box approach for a whole range of duties and obligations of the parties, and the copyright and intellectual property is no exception. While the ConsensusDocs does have boxes and blanks you can fill in to determine who gets what, if you leave everything blank under the ConsensusDocs, the copyright stays with the designer. Under the AIA, the B101, it's a familiar concept that the architect grants the owner and others involved in the process a non-exclusive license in their instruments of service, and that non-exclusive license gives the parties rights really just for a particular project to do certain things with those documents. Next slide, please. Under the ConsensusDocs 240, an owner does have the right to use the documents to complete the project if there's a termination for convenience or a termination for cause. And interestingly, under the ConsensusDocs, the owner can even use the documents for derivative works. Now, that's a term of art that we don't have time to get into here, but what it can mean is the owner may use those same drawings and specifications potentially for additions or perhaps other projects, depending on the specific use. Under the AIA, the B101, you see that the non-exclusive license granted by the designer terminates if the owner doesn't pay what's due, if the architect terminates for cause, or if the owner does not pay an extra fee after a termination for convenience. Next slide, please. I wanted to get to this slide because it gets to several issues that are new to the AIA documents. I say new. As of 2013, the AIA brought out a new series of documents dealing with building information modeling and digital data. And let me start with the AIA on this particular slide. The AIA under the B101 states that the parties can use this E203, the 2013 edition, which is the BIM and Digital Data Protocol exhibit. Now that exhibit incorporates or can incorporate other forms as well. One of those I have listed there is the G201 2013, which is the Project Digital Data Protocol form. And what it does is it establishes procedures, as you'd expect, for how you handle the data. How do you send it? Who controls it? Interestingly, under the new E203, the AIA has added a provision that relates specifically to confidential data. A couple of the other points of the AIA are that there is a warranty of ownership, but the participants do not provide a warranty of correctness of the data. The AIA does provide a limited license to use the documents, which is also similar to the ConsensusDocs approach that I'll run down in a second here. And the AIA provides an indemnity by the receiving party in favor of the transmitting party for any unlicensed use or modification of the data. Now on the ConsensusDocs side, the ConsensusDocs document is the 200.2, the Electronic Communications Protocol Addendum. And like the AIA, it sets out the procedures and a framework for how documents and information are transferred. I mean, one thing that I would say about the ConsensusDocs, and I would say this even if you prefer the AIA documents, you really ought to pull up a ConsensusDocs 200.2 to look at some of the types of issues that are covered in the 200.2, really starting in Section 4 and following of that document. I mean, there are just an incredible number of decisions you can make, boxes you can fill in, how to, what sort of formats to use for your files, what sort of hardware, what sort of operating system is going to be required, workstations, CPUs, I mean down to monitors, input devices, printers, plotters, scanners, video cameras, software requirements. I mean, it's just a really, really, and I find it very useful, it's just sort of an exhaustive list of the sorts of information technology issues that you might ought to be thinking about as you're going through BIM or transmitting documents electronically. Like the AIA, the ConsensusDocs grants a limited license to use the documents. Unlike the AIA, ConsensusDocs has a mutual indemnity for any damages from any party's failure to conform to the protocol. And of course, the protocol is what's set out in the document itself. So, in a sense, the ConsensusDocs has adopted the approach, you're responsible for your own information. If you fail to conform to what you've agreed to do, then you're going to indemnify another party for that. But by the token, another party will indemnify you for their failure to conform for any of the issues listed in the document. I'll go ahead and mention that under the AIA, they've also updated the C106, the 2013 edition. It's largely similar to the prior edition of their digital data licensing agreement. And before Carrie uses her electronic shepherd's crook to tell me my time for this section is up, I'll say that this last issue of indemnity with respect to transmission of documents is a good segue into Sam's first topic.
Yes, and this is Sam Reaves. Tim, thank you. Terry, thank you very much. I'm going to be talking a little bit about comparing the ConsensusDocs and the AIA documents in terms of indemnification. Aside from a few issues that Tim has mentioned, the AIA documents really don't have indemnity obligations on the part of the architect, except with respect to the transmission of documents and some of the BIM issues that Tim has talked about. So the AIA documents don't just have sort of a fundamental obligation on the part of the architect to indemnify the owner for third-party claims caused by the architect's negligence. Now, contrast that to the situation with the AIA forms for the owner-general contractor agreement, where the general contractor does have indemnification obligations. And really, whenever I'm representing the owner in one of these, one of the first things I do if I'm dealing with the AIA documents is to add an indemnification obligation on the part of the architect, because that's important. The architect's mistakes can certainly cause claims against the owner and cause losses to the owner. I've been in situations before in different cases where the lack of indemnification in a contract that somebody may have drafted years ago made a difference. I was reminded of a case in preparing for this where there was a home builder who had sold homes to the home builder's customers, and the homes had some settlement and some structural damage. The home builder had to pay amounts to the customers to fix the homes, and then sought that from a geotechnical engineer, design professional, for the structural damage. And the geotechnical engineer said, sorry, those are third-party claims and they're not covered by my normal negligence, my normal liability for negligence, and there's no indemnification in the contract, so too bad, you're out of luck. The court ultimately didn't have to rule on that argument because the matter was settled. But indemnification is something that does make a difference. Contrast the AIA approach with the ConsensusDocs 240 approach, which is a mutual indemnification concept, and it's based on comparative negligence. So it would include the architect indemnifying the owner to the extent of the architect's fault for third-party claims, and it would likewise include a basic indemnity obligation on the part of the owner to indemnify the architect for third-party claims that are personal injury or property damage, and that result from the owners or somebody basically other than the contractor from their activities at the site. So if there's a part of the site that is not under construction, that the owner rather than the contractor controls, and an architect employee is injured, there would at least be some basis for indemnity under the ConsensusDocs. And by the same token, the architect would have a basic indemnity obligation to the extent of its negligence to indemnify the owner for personal injury or property damage. So it's mutual indemnity based on a comparative negligence concept. There's no duty to defend. There is ultimately recovery of attorney's fees as part of the indemnity obligation. And if either party steps up and pays more than its fair share of attorney's fees in relation to the percentage of fault that's ultimately determined, it's entitled to a refund of those. So I think the ConsensusDocs presents a situation that's more fair to both parties and really a lot more in line with expectations and commercial reality. And as I mentioned, the AIA doesn't really have indemnity by the architect. There is, in the main AIA form, the B101, there is an indemnity in the B103 for large projects for third-party claims caused by the architect, but that's only to the extent of insurance proceeds. And of course, the B101 is much more commonly used than the B103. So that's one essential difference in terms of indemnification. In terms of other indemnification obligations under the ConsensusDocs, and here the ConsensusDocs and AIA are not terribly different. Under the ConsensusDocs, the owner indemnifies the architect for post-construction prohibited use of documents. So you can go ahead and go to the next slide, Gary. Okay, yeah, we're there. So the owner indemnifies the architect for post-construction prohibited use of documents. So if the owner goes ahead with an addition to the project or another project or any sort of other use that technically the owner may be allowed to do, but does that without the architect's involvement, there's some indemnity for that. That is essentially a similar concept of what's in the AIA documents. The ConsensusDocs have another provision that is important for owners, which is the architect has to indemnify the owner for negligence-caused delays. That's in Article 5.2 of the ConsensusDocs 240. So if the architect is late with the plans and is negligent in that lateness, that it's not some sort of a delay that's excused, then that is something for which the architect owes the owner indemnity. That contrasts with the AIA documents, which again don't have that kind of obligation on the part of the architect, and it's also very much in line with what owners expect, because a delay by a design professional can have real consequences. Now, the ConsensusDocs indemnity obligation for delay excludes consequential damages. So there's a waiver of consequential damages in Section 5.4 of the ConsensusDocs. So we're not talking about the owner having to provide indemnity for lost profit expectations, but for example, to the extent that the architect's delay causes a contractor delay and there's a contractor delay claim and there's something that may not be a consequential damages, may not be a consequential damage, that could be covered by the architect's indemnification obligation. In terms of other indemnity, there's a mutual patent and copyright indemnity provided in ConsensusDocs, and that basically says that if the owner requires that a particular process or particular design be used, and as a result of that, there's the architect basically gets sued for intellectual property infringement, and the owner provides indemnity. If the architect, as part of coming up with the plans, includes a design that infringes on somebody's intellectual property rights, and the owner gets sued as a result, then the architect has to provide indemnity. Contrast that with what the AIA documents say, which is essentially that the owner and architect each want the ownership of information that they furnish to the other. So not as broad, not as much protection as an indemnity. The next topic, we can go to the next slide, is standard of care. If you look at how that's defined in ConsensusDocs versus the AIA, ConsensusDocs talk about the standard of care being the standard of care required for a project of similar size, scope, and complexity during the time in which services are provided. So it's a little bit more specific than what the AIA states. The AIA basically says the same or similar locality under the same or similar circumstances. So the ConsensusDocs include more specificity in terms of a project being of similar size, scope, and complexity, and the ConsensusDocs also include a kind of a temporal relevance standard where it's got to be during the time in which the services are provided, because as we all know, the standard of care, what's expected of an architect or other design professional, evolves over time, especially in light of some of the technology issues that Tim has talked about. Next slide. The next slide talks about relationship of trust and confidence, and here I would say the AIA kind of has a traditional approach. It doesn't say anything about the architect being a fiduciary or almost a fiduciary of the owner. The ConsensusDocs say that the design professional accepts a relationship of trust and confidence with the owner. That is the traditional kind of language you put in to establish a fiduciary relationship. So the ConsensusDocs reflect the special relationship that represents, or that is in effect between an owner and an architect, and give some nod to that and the fact that the owner is relying on the architect, and the architect is supposed to look out for the owner's best interests. That's in Article 2.2 of the 240. Similarly, in 2.2, it's not all just one way from the architect to the owner. The other language in 2.2 says that there's mutual trust, a relationship of mutual trust, good faith, and fair dealing between the architect and the owner. So the ConsensusDocs speaks a little bit more to the relationship of trust between the owner and the design professional. Next slide, please. In terms of the standard of completeness of the documents, the ConsensusDocs talks in terms of the architect or design professional providing architectural and engineering services necessary to design the project. So it's a little bit broader than how that's termed in the AIA. The AIA basically says the architect will provide the services set forth in the agreement. So ConsensusDocs is all the services necessary to design the project, which is more in line with what the owner's expectations really are. The ConsensusDocs also the ConsensusDocs forms also says that the construction documents at the end of the construction documents phase, the construction documents will describe all work necessary to bid and construct the project. So again, broader than what the AIA says, which is the construction documents will set forth in detail the quality levels of materials and systems and other requirements for construction. So I'm going to turn it back over to Tim now to talk about BIM, Building Information Modeling.
Thanks, Sam. Going back to a slide that you've seen before, this is not a mistake. It is, again, worth revisiting how far we've come with the technology, and the concept that is added in BIM essentially is the concept of collaboration. As CAD became more powerful, you could put more information in the lines that were being put down on paper, so to speak. The databases, as they became interactive, different people could input different information. You now have cloud computing where you can have entire sources and repositories of data off-site somewhere else. People go to it. We might not even know exactly where it is, but the idea is collaboration. Next slide, please. Now, collaboration is not something that has, is a new idea. When you think about it, you go back to even something as simple as a shop drawing from, say, maybe a cabinetry subcontractor who has put together the detailed designs for the cabinetry. There's a level of collaboration involved in that. Specifications have a level of collaboration. For example, think of a curtain wall system. As an architect, I don't know that I would sit down and try to design one, but there were manufacturers who had them, who could provide specifications. I could specify them, and I was in a sense relying on their skill in putting that into a building. Concepts like value engineering, where people get together and say, okay, it's too expensive. How do we get some money out of this project? Design build itself is a collaborative process. And then concepts newer in time, partnering, although that one seems to have been a little bit trendy. But the overall view is a collaborative approach is what's driving BIM. Next slide, please. If you go to what I think is an interesting definition from an older publication from the AGC, which defines a building information model as a data-rich, object-oriented, intelligent, and parametric digital representation of the facility, which is, of course, a mouthful. But you get an idea for what BIM is, what the model is, and the idea is to improve the process of delivering the facility. Next slide. When you go to the AIA definitions, again, a very similar approach. Building information model is a digital representation of the project or portion of the project and is referred to as the model, which may describe a model element, a single model, multiple models used in the aggregate, as well as other data sets. Now, one thing, and I've pulled that definition out of the E203, the 2013 edition. One thing you'll see in the 2013 documents from the AIA is it seems that, and this is purely from my perspective, that they are going to a sort of a more abstract approach to BIM. Next slide, please. The ConsensusDocs 240 requires the use of BIM if the owner decides it's to be used. By the way, on the ConsensusDocs on BIM and some of the other issues, ConsensusDocs are, or at least do, appear to be more owner-driven in certain of the processes. Like, for example, if there's some sort of deadlock in how information is to be used in BIM, the owner gets to break that deadlock under ConsensusDocs. Under the AIA, it's got a new series of exhibits and forms. I've got them just listed for you there. The E203, which replaces the old E201, and then two forms, the G201 and the G202, which I'll discuss those in a little bit more detail. Next slide, please. The ConsensusDocs 301, which is the main document from ConsensusDocs perspective on the general principles, it does not restructure any of the other agreements. Contrast that to the AIA, the E203 is incorporated by reference into other agreements. Under ConsensusDocs, back on the other side of the chart, parties, you can simply append or you may incorporate. You have that choice. Continuing down the ConsensusDocs side, it doesn't change the designer's obligations or the designer's role, and it doesn't change the owner's warranties as to design. Interestingly, under the AIA, all parties in the process are third-party beneficiaries to each other. And the level of development has changed, in my view again, this may not be a widely held view, to become sort of a more abstract look at the level of development. And in particular, one thing that I think is yet to be seen under the AIA side is to what extent the third-party beneficiary principles may have an effect on authorized uses on the level of development. Now, go to the next slide, and while you're going to the next slide, I've got for you there the old E202, the 2008 edition on level of development, and then the new G202, the 2013 edition. In most instances, the wording of the level of development or the description of the level of development is more abstract. And I'm not going to read those for you. I'll simply say that under the previous AIA edition, at least as I read it and looked at it, I thought you could see in it that it went sort of as architect services have traditionally gone, from schematics to DD to construction documents, and then to more complete drawings for detailing like shop drawings. Now the language of the level of development, for example, the level of development that I would have thought of as schematic previously, describes it as a symbol or other generic representation, but less than the 200 level of development. And that continues the idea I've talked about previously of the AIA sort of going to a more abstract approach. What I'm concerned about under the AIA is, in addition to this sort of more abstract description of the levels of development, there's now something called authorized uses, and I'm going to read something to you, which I hate to do in a presentation like this, but there is a very helpful guide that the AIA publishes. It's the Guide, Instructions, and Commentary to the 2013 AIA Digital Practice Documents. And here's the concept that I'm concerned about, and I'm reading from page 27 of that guide. If an LOD 200 model element contains specific information regarding the location and type of a light fixture to be used, the information can only be relied on consistent with an LOD 200, because LOD 200 means the model element is represented as a generic system, object, or assembly. Therefore, even though the information regarding the light fixture is specific, because the model element is indicated to be at the LOD 200 level, the information cannot be relied on as specific, and instead can only be relied on to the extent appropriate for generic information. Now, if that confuses you, it also confuses me, and it makes me wonder whether AIA's intent, I think, to get somewhat more abstract in the models may have resulted in some issues that may be difficult for us lawyers to ferret out down the road. Next slide, please. ConsensusDocs has not changed the 301. It's got different types of models leading up to a federated model and a full design model. Again, I'm not going to go through all the differences between those. But again, the ConsensusDocs, it appears to be more geared to sort of a practical use of the model instead of an abstract description of it. What I'm going to do now is suggest that we skip the next slide and go to the next one. In the 301, again, another document worth looking at, even if you prefer the AIA documents, the BIM execution plan has the information about all the participants, their identities. They define and update the models, and a whole list of procedures and protocols starting in section 4.3.9. Again, that's worth reviewing, even if you don't, if you prefer to use the AIA documents. The AIA, using the G202 form, has or can have long list of model elements. They rely on model element tables in the G202, which really, again, from my view, simply sort of divide up the model into sort of every single piece that there can possibly be of the building. In fact, they have 3 different versions of the G202, one of which uses in its model element tables the CSI uniformat designations, a different version that utilizes the Omni-class designations, just a different set of specification terminology, and then what I'll call a generic version where you sort of fill in how you want to use it. And that's the end of my part, which is kind of a curious segue into Sam's section on termination.
All right. Thanks, Tim. We're going to talk about termination and right of withholding and then dispute resolution. So in terms of termination, both ConsensusDocs and AIA provide for the owner a right to terminate for convenience. I won't spend a lot of time on the differences because these provisions between the two are fairly similar. Both documents provide a right to terminate for convenience upon 7 days written notice. The way that what the architect can recover in the event of a termination for convenience is pretty similar. It's described a little bit differently. For example, the AIA document has anticipated profit included and a licensing fee to continue to use the documents included for termination for convenience. ConsensusDocs doesn't have either one of those set out specifically, but does leave a blank for a termination premium that's set out in the agreement, so the parties can negotiate what's going to be paid. In addition to just direct out-of-pocket losses from the termination, the parties can negotiate what's going to be paid by the owner for a termination for convenience, which would presumably include things like whatever the parties agree on with anticipated profit. Turning to termination for default, next slide, please. The ConsensusDocs provides a mutual right to terminate for material breach. That's similar to the AIA B101. What the ConsensusDocs do that's different and helpful here is to say that a termination for default or cause requires 7 days notice and opportunity to take appropriate corrective action. That can be thought of as an opportunity to cure. The AIA documents say 7 days written notice, but they don't mention an opportunity to cure. So it's 7 days notice, but without an indication of what, if anything, can happen to correct the default within those 7 days. So the ConsensusDocs are more specific. Most parties, both sides, want and expect a right to cure a default if it's something that can be cured. Another difference is that ConsensusDocs provides that after those 7 days and opportunity to take appropriate corrective action are up, the terminating party then has to provide a second notice, which is a declaration of termination. So the party, there are basically 2 notices that have to be provided with a termination for default. One is the original termination notice that would provide 7 days opportunity to take appropriate corrective action, and then there'd have to be a second notice that actually says the corrective action was not sufficient and the contract is actually terminated. Next slide, please. The consensus docs includes an express work continuation clause where the architect is obligated to perform services during any dispute proceeding, and the owner is also obligated to pay undisputed sums during the dispute proceeding. The AIA doesn't get that specific. The architect still has a termination right for a material breach, which would presumably include a failure to pay. So if there's a good faith dispute about the amount that's owed, there's a termination proceeding pending, then the architect does have to continue working. Otherwise, if the architect simply not paid, the architect has the termination right. The AIA documents talk in terms of the owner's failure to make a payment being a substantial non-performance and ground for termination or a suspension of services. And the B101 goes into the architect's right to stop work, suspend services, and what the architect gets paid in that event. So in that regard, the consensus docs is a bit more concise, to the point, talks about the architect's right to terminate. Another important distinction between the two documents is the owner's right to withhold payment. So this folds into the termination and dispute resolution provisions, and sort of a bridge between those two. The Consensus Docs 240 provides that the owner has a right to withhold payment for damage, default, or failure to perform on the part of the design professional. The AIA says that the owner has no right to withhold payment unless the architect is actually found liable in a binding dispute resolution proceeding. So under the AIA concept, you actually have to go through full dispute resolution, and the architect has to be found liable before the owner can withhold payment, which is not much of a right of withholding. If you've got to go all the way to the end of a dispute before you find out whether you have the right to withhold, essentially no right of withholding at all. Again, when I'm negotiating an agreement on behalf of the owner, a right of withholding is something that dealing with the AIA documents I always add in. Next slide, please. Dispute resolution. Here there are some important differences, again, between Consensus Docs and AIA. Here I think the overarching theme is the Consensus Docs provide more of an emphasis on early resolution through informal negotiations. So the Consensus Docs have stepped up negotiations before you get into any sort of more formal dispute resolution proceedings. So the Consensus Docs contemplate that the party representatives are going to talk. After that, senior executives of the parties are going to talk. After that, the parties can really go one of two paths. They can go through formal mediation, or they can go through what's called dispute mitigation, which would be an appointed neutral or dispute review board that takes a look at the claim, makes a pretty fast but non-binding decision on it to try to resolve it. So basically both sides get the benefit of saying somebody neutral who's qualified has taken sort of almost a quick peek at this, has issued a decision based on initial impressions and sort of the most relevant information, and here's that decision. So do you want to go forward with a more formalized dispute resolution? The AIA is what I would call more of a traditional approach to dispute resolution. It basically doesn't say anything about direct negotiations really, or about dispute mitigation between the owner and the architect. It's basically mediation as a condition proceeding to arbitration or litigation, and then would have arbitration or litigation, and there's no default selection of arbitration if nothing is checked, arbitration is not chosen, disputes are litigated. So the Consensus Docs process, again, puts more emphasis on informal negotiations occurring early on to try to resolve the matter before it gets to even to mediation, and much less to arbitration or litigation. Next slide, please. This graphic really illustrates what I was talking about in terms of the Consensus Docs dispute process. You'd have, again, party representative discussions, senior executive discussions, that's important. I've found in my experience that a lot of times people at the project level are sort of the party representatives who initially talk about a claim and try to get it resolved. They can become pretty entrenched pretty quickly because sort of their own performance is on the line. They have a vested interest in how it's resolved. So too many times it's not really kicked up to senior executives who have a little bit more distance from the issue and evaluate it a little bit more dispassionately. And then it may go straight to mediation. At that point, a lot of times I've seen mediations just become sort of a hollow process. It's just people have decided they want to sue each other, they want to arbitrate, and so they've got to check the box, they've got to jump through the hoop of mediation, and so they'll set up a mediation just for the purposes of checking the box, and it's a mediation that doesn't go anywhere. Consensus docs allows for more meaningful discussions before that point. So again, you'd have party representatives, then senior executives. Then you have the opportunity for mitigation with a project neutral or dispute review board, so you get a chance for somebody who's neutral to sort of give a first pass on the claim to give an indication of what an outcome might look like. And it's surprising how often that helps. A lot of times a party who is all pumped up about its chances and its claim will get a decision that's adverse and realize that maybe it's not worth it to go forward. So that can really take a lot of wind out of somebody's sails who wants to take an unreasonable position. Next slide, please. One potential critique of the consensus docs disputes procedure is it requires a lot to happen early on. I mentioned a couple of times the multiple informal negotiations, sort of the stepped-up negotiations. The consensus docs provides some pretty aggressive timelines for that to occur. The initial discussions for the party representatives, once they start, they only have 5 business days to resolve those. Then the senior executives have another 15 days. From there, it goes either to mitigation or mediation. If it goes to mitigation, it's supposed to be decided, a non-binding decision within 5 business days of referral, unless good cause is shown. So that's a pretty accelerated time period. So again, there's not a lot of time to be gathering a whole lot of documentation and evidence. That's really forcing both sides to put their very best foot forward based on the most important information that they're likely to have rather than some full discovery procedure. So again, only 5 business days for the neutral or the dispute review board to issue a decision is pretty aggressive. And then there's a pretty aggressive timeline for mediation if that doesn't work. Next slide, please. The AIA disputes procedure, as I've already alluded to, is what I would call the more traditional procedure. There's an option to choose the architect. It's what's called an IDM, or initial decision maker, but those are for disputes between the owner and the contractor. There's really not this mitigation concept where the owner and the architect could go before a neutral or dispute review board first to try to get a non-binding decision on disputes. Then the AIA has basically checked the box, arbitration or litigation or something else. If the parties desire to do something else, they can fill that in. Mediation is, again, a condition precedent to litigation or arbitration, so there's really no period of negotiation required. The parties just go directly to mediation. The AAA or the AIA rules provide for the AIA document provides for AAA rules and administration to govern arbitration. If you contrast that with consensus docs are more flexible. Going back to Tim's point, they sort of have a check-the-box approach. You can choose AIA rules, but not AAA rules, but not AAA arbitration. You can choose jams instead. So the consensus docs contemplate what's becoming more and more the case, that the parties may want to select an arbitrator and have that arbitrator or panel of arbitrators administer the arbitration without having a big organization like the AAA actually administer the arbitration. So consensus docs are designed to be a little bit more flexible in that regard, to give more options if you do choose arbitration about how that arbitration is going to work, rather than just being a default that it's going to be AAA rules and AAA administration. Next slide, please. Importantly, the consensus docs have a attorney fee shifting provision so the prevailing party recovers its attorney's fees. The AIA documents don't have that kind of concept. In terms of statute of limitations, the AIA documents kind of provide a presumptive statute of limitations proposed where claims have to be commenced within whatever state law says about the statute of limitations or repose, but they can't be commenced later than 10 years after substantial completion. Really, both sets of documents, both consensus docs and AIA, provide for a waiver of consequential damages, and both talk about when an arbitration is commenced for statute of limitations purposes. It's basically receipt of the arbitration demand by whoever is administering the arbitration. In 2014, consensus docs were revised a little bit further to add that if a matter starts out in court and then goes to arbitration, that the relevant date for beating the statute of limitations is generally when the case was filed in court originally, so it gives a little bit more protection if one party or the other is trying to beat a statute of limitations. Next slide, please. Consolidation and joinder in terms of dispute resolution. That's always an important topic because it's important to get all the parties in the same proceeding if that's possible. There may be a dispute about whether it's a design defect or construction defect, so it may be in everybody's best interest to have the owner, the architect, and the contractor in the same proceeding, which is a lot harder to happen if they have different dispute resolution mechanisms. So the consensus docs takes an approach of basically saying parties agree that all parties necessary to resolve a claim will be parties to the same dispute resolution procedure, and then it puts the onus on both parties to go out and in other contracts they enter, for example, the owner-contractor agreement, to put in a similar provision that would allow all parties to be joined in the same proceeding. The AIA documents take, again, what I would call a more traditional approach. They say parties can be joined if all these conditions are met, one of which is the party to be joined has to consent to be joined. And then they say that proceedings can be consolidated, but again, only if all these conditions are met. The other arbitration agreement has to permit consolidation. There have to be substantial questions of law or fact that are in common, and the arbitrations have to employ materially similar procedural rules. You can go to the next slide. So in terms of consolidation and joinder, the consensus docs present a sort of a more practical approach and have more obligations on the parties to facilitate consolidation and joinder. They basically say that it's up to both parties to go out and enter into other agreements that have similar dispute resolution provisions, and the parties go ahead and commit in the document to trying to join all the claims in one proceeding. So the consensus docs have an approach that is both more flexible and more supportive of consolidation and joinder of dispute resolution proceedings. And that is the end of what I have to say about dispute resolution.
Well, thank you so much, Tim and Sam. We really appreciate it. It was a great presentation. We do have some questions. We have some time left, so I will get to the questions from our attendees. And let's see here. The first one is, how does the designer retain ownership of quote-unquote typical details if the copyright is granted to the owner?
Looks like that's probably directed to my side of it. I think they probably don't. If the copyright is granted to the owner, then the owner is going to have the right to use those standard details. Now, I guess I'm not sure exactly whether the question is trying to get at whether, okay, if it's a standard detail, I guess there's some idea that it's already out there circulating around. It's been used on hundreds of projects. So to that extent, probably it's possible it would not be protectable because it's so widely used. I will go ahead and confess that while we do have 2 patent lawyers in our firm who look at a lot of intellectual property things, I'm not one of them. So it's a little bit above my head. But again, to the extent intellectual property rights are granted to the owner, the architect's not going to have the rights unless there's some other reason why they would be otherwise, could be otherwise unprotectable.
Okay, great. Another question here for Sam. It says specifically for Sam, what has been the success in getting architects to accept the indemnification provisions in the ConsensusDocs 240? And quite frankly, even though it's for Sam, Tim, if you have comments, feel free to comment as well.
Okay, Terry, can you say that one more time? You didn't hear everything.
Sure, I'm sorry. The question is, what has been the success in getting architects to accept the indemnification provisions in the ConsensusDocs 240?
They're usually open. Most architects understand that the owner expects indemnity, and most architects understand that, you know, a professional negligence, an error or omission on the part of the architect can result in claims against the owner, and that's a pretty reasonable expectation on the part of the owner, especially if there's some mutuality of the indemnification obligation. So a lot of times where I end up is the architect has an obligation to indemnify, and then the owner has an obligation to indemnify as well, although, you know, the owner's indemnity is by necessity more limited in terms of personal injury or property damage, because the owner doesn't really control a active site that's under construction. So usually if there's some mutuality of indemnity, the architect will agree to some basic indemnification obligation as long as it's tied to the architect's negligence.
And that we've had similar experiences as well. We've represented some really large owners who in their contracts with designers have included not only the indemnity provision, whether it be ConsensusDocs or a custom drafted document, but we also always include a standard of care. And of course the standard of care can be very relevant to the indemnity, because if you have a breach of your standard of care, then that's going to trigger your duty to sort of pay for whatever those mistakes were.
And I think you may have even touched upon just there the next question, that doesn't the standard of care in ConsensusDocs make that system much more desirable from a designer's point of view? Let's see. The next question here is referring to complete construction documents. How would that relate to HVAC, mechanical, fire sprinkler, fire alarm, etc., that are designed by others in a traditional design bid build project?
Well, I would certainly welcome any thoughts that Tim has on that. I mean, I will say the way ConsensusDocs are phrased is all design services, including architect and engineering, necessary to construct the project, and then it talks about in another section about subconsultants. So I think it anticipates the architect would provide all those services at least through subconsultants. That's not terribly different from the AIA. The AIA says the architect will provide the services specified, and then I think it's in Article 3 of the B101 says that that includes customary MEP engineering services.
I agree with that. That's a good answer to that question.
Great. Another question here is, my client has been providing project schedule status reports created in Microsoft Project to the owner in PDF format. Under ConsensusDocs, would they be required to provide the native Microsoft Project file in .mpp as well?
I'm going to take a stab at that one, because that actually gets at a couple of different issues, one of which we didn't discuss. But under the ConsensusDocs, if you look at the, and I'm going to go back to it right now, the 200.2, it actually lists permitted file formats for everything you can imagine in a project. And so the parties, the ConsensusDocs gives the parties the ability up front to choose, okay, we're going to do it in PDF, yes or no, or that sort of thing. The other issue that touches on native format is probably one of the biggest issues currently in litigation, which is electronic discovery. And so I guess I would say, yes, it's nice to have these provisions in contracts that state, yes, we're going to provide things in this particular mode, but just be wary of the fact that if there is a later dispute, there's a great likelihood, at least in my view, certainly in court, and a fairly good likelihood in an arbitration, that native format documents are still going to have to be produced. But that's, like I say, that's outside of what we just talked about. But it does, you know, it's one of those things where you've got contracts. Yes, we've done what the contract says, but be aware you may have to do something else later.
Super. Well, thank you. I've got 3 o'clock on my computer here, so we're going to close this down. I want to thank you, Tim and Sam, for a very informative presentation. I'll thank our participants for joining us today. We hope that this webinar helped you learn at least a few of the differences between ConsensusDocs and AIA standard contracts. We will be sending you an evaluation form that will be emailed to you immediately following the webinar. We'd love to get your comments. Your feedback will help us plan future educational events. We will be sending a copy of the PowerPoint as well, and give us a few days, but once IT can get it wrapped up for us, we will be posting the audio recording as well as the actually the audio and video presentation will be posted to the ConsensusDocs website within about a week. So thank you again. This ends our program, and I hope you have a wonderful afternoon.